So we're here with Kevin Yeanoplos. Thank you for joining us.
My pleasure.
Kevin, you're one of my favorite experts and teachers of business valuation. How do you value a business in divorce?
You know, if you had stopped that right after, how do you value a business? I would have given you a different answer because the rules are different for divorce. Just earlier today, I was talking to somebody that had called me about my expertise with a particular industry. And we talked about the fact that, generally speaking, one of the three things we look at, which is namely comparable sales, we typically do not do that in a divorce case, and I'll get more into that. So how do we value a business? Well, it's at a 30,000 foot level. It's very similar to appraising real estate, and probably everybody listening either has a mortgage or they're familiar with an appraisal of their house if they're getting some borrowing. And we look at three things. We look at the income approach, the market approach, and the asset approach. And to carry on with that real estate analogy, if we were renting the house and we took the present value, we took all of the future rents that somebody was going to pay on that house and brought them back to today with some interest rate. We bring them all back. That would give us a value. So the income approach, looking at what it can generate in income or cash flow or whatever. That's one way to do it. That is very commonly used in divorce cases. That's really the conceptual, probably the most conceptually correct way of coming up with the value of any company, because cash is king. Cash is what people hope to get out of an investment. So that's important. The market approach, what we're trying to do is find other assets or businesses just like the one we're valuing that have sold. That'll give us a benchmark to use. And if you think about that real estate appraisal, what the real estate appraiser does is he finds houses in the same neighborhood, the same street or whatever, and he compares the characteristics of that house to the one that he's appraising. For instance, number of bedrooms, number of bathrooms, square footage, whatever those characteristics are. And by comparing the characteristics of the home that sold, the comparable, to the one we're trying to appraise, we get some idea as to whether or not it's more or less valuable than the house that's sold. So we're comparing all of the characteristics between the two. It's very similar in valuing a business. We're comparing figuratively the bedrooms, the bathrooms, the square footage. As you might expect, it's much more difficult to compare the companies that have sold to the company we're appraising, because it's not as simple as simply looking at those differences. We may not know what the differences are, and that's why sometimes it's very difficult to use the market approach in a divorce setting, because we may think we're comparing them and making adjustments for the differences when we don't really know what the differences are. I see that approach misapplied a lot because of that very reason. And the third way is what we call the asset approach. Carrying that real estate analogy to completion, If we're appraising a house, we ask ourselves, what would it cost us to completely rebuild that house from scratch? And that's the same question we ask with a business. What would it cost to rebuild that business from scratch? We would need to buy equipment. We would need to buy furniture. We would need to buy intangible assets, goodwill, customer relationships, accounts receivable. So it can be done, but the asset approach with a profitable operating business is really the most difficult to apply. The market approach and the income approach are considered top down. And what I mean by that is when we come up with a value for the company using those two approaches, it includes the value of everything. It's all of the tangible assets. It's all of the intangible assets. I may get a client on occasion say, well, does this include such and such? Yes, if it's a top-down approach, it includes everything. Market approach and income approach are top-down. The asset approach is bottom-up. And what I mean by that is it's as if we were building a new company. So we're going to need a brick, a figurative brick for accounts receivable. We're going to need a figurative brick for equipment, a figurative brick for a building, whatever it happens to be. So we're stacking those bricks on top and we're building this company, and each brick costs us something. And we add the value of all of those costs together. And in theory, that's what it would cost to recreate that business.
From the family lawyer's perspective, we see business owners both as being represented by us or opposing counsel. There's a business, there's value to the business, and the business has to be divided. And lawyers call that being divided, but it's not divided. If you would share with us some of your experience on how you've seen most typically businesses split in a divorce.
All right, you said typically, but I'm going to start with the atypical situation first and get that out of the way. And that is that the business is actually sold. There are times, for whatever reason, maybe it's the parties can't agree and the trier of fact doesn't want to split it. They may just say, look, you just go sell it and we'll split the proceeds. Enough fighting over what the value is and isn't. So that's the atypical. The typical is that I'll just go through the situations. I've been involved in, for whatever reason, maybe one party gets an expert and determines the value. The other party does not. Obviously, if only one party gets a valuation, the judge has, I think, less leeway because here's an expert saying this is what the value is. And there's nothing, there's no benchmark, there's no competing, there's no opposition to it. And to me, that is the, I don't know, I guess the worst scenario for somebody to find themselves in, where there's one expert on one side and the other one doesn't have one. That's, to me, that's dangerous. Sometimes an expert is jointly engaged, and for the most part, both parties agree to accept whatever that value is. And that is a way to minimize fees. And for the most part, I think it's a good way to do it. It's successful most of the time. There are times when one or the other party doesn't like the number. And so One side doesn't accept it. I just testified in a case where both parties hired me. One liked it and the other one didn't. And I will just say this, that after my testimony, the attorney that I wound up working with remarked to me that they'd never seen an expert treated with less respect in the courtroom. So in essence, that's what happens, because I suppose the attorney that had jointly hired me at first had to then make me look as bad as possible to show that she had made a bad decision or something. But anyway, so that happens a lot. The other thing that happens, of course, is where both sides have an expert. And my experience is that most cases settle before they go to trial for whatever reason. And so having an expert on both sides is helpful because it enables the parties to negotiate, so to speak. You know, this answer is like a 8-hour answer.
I know. Don't blame me, blame Google. Now, we have assumed the parties have negotiated a number.
Okay.
And they ask you, let's say that number is $1.5 million. Just picking a number out of the blue. How do we mechanically split that?
Okay. I misunderstood your question.
No. Getting to the number is good.
Sure.
That's an important, you would agree with me that getting the number is the first step.
Sure it is. And
I will just... Then we got to figure out how to pay it. And in that case, with 1.5, if you're doing a 50-50 property division, we've got to transfer $750,000 to the non-owner spouse.
Yeah. And usually what will happen is I'll call them the ownered spouse, of course, the one that's going to continue owning and running the business, would get the entire business and make some kind of an equitable distribution the other way of other assets, whether it be retirement funds or maybe the ownered spouse will sign a note to the non-ownered spouse to pay them over a certain number of years for that amount if they don't have the assets existing to be able to make that transfer. On rare occasions, the two parties will still continue to be shareholders. So they'll each own a piece. And sometimes if you get a business that has a lot of potential, both parties may want to continue to own it. That does happen at times.
So in your experience, how often are you working with a client and a bank to try to work out this cash flow issue?
In a divorce case?
Yeah.
I'm going to say for me, it's rare. And the reason I say that is because that almost tastes like a conflict of interest to me. Because what happens is one or the other party is trying to obtain financing, and they really need somebody to advocate for their position. Because if they're trying to get the bank to give them certain financing at a certain rate, somebody's going to need to lobby for the value of that business. So usually I'm not the same person that's involved in that discussion. I think it's a conflict, and just coincidentally, one of the most important pieces of information in a divorce case are loan applications. because somebody at some point has indicated what they think the business is worth, which may have no, you know, semblance of reality, but it's still, you know, if you get an owner filling out an application that he thinks the business is worth 5 million, and then in the courtroom, he's trying to take the position that it's only worth 1 million, is that loan fraud?
Yeah, we actually had that almost exact same fact pattern in a case that, as you know, Mr. Vance from Memphis talks about and testified in many years ago. We had that exact same fact pattern. And what I think is helpful to lawyers is to see the process that coming up with the dollar amount, the figure, is so vital, because from there it drives everything else in terms of what can be borrowed. What you described earlier was the offset method. Do we have 3 million in retirement savings and we just cut an extra 750 to the non-business owner spouse?
Right.
Or are we going to be required to create a note being paid out by the business over a 20-year period, 10-year period? What's that interest rate?
Right.
And then do you have security for the business ownership, which could be the stock or ownership of the business itself? And one of the things that I always share with young lawyers is I'm not drafting that myself. I don't have the competence for that. And I don't think many family lawyers do. That's why God created business lawyers.
Right, right.
What advice can you give a young family lawyer early in his or her career who wants to take a deep dive into business valuation? Where should he or she start?
Well, I'm going to say right off that it's a bit of a caveat, and I'm fairly certain that you would at some point have this same discussion, which is, remember that you are a legal expert and you're not supposed to be a valuation expert. So you might rephrase your question as to, you know, where does the new attorney start to know just enough to be dangerous? And that might be enough, frankly, to just understand. I think personally, there are a couple of things. Find an experienced family law attorney in the area. You know, you would be a fantastic resource for a new attorney that's trying to get a feel for how things work and the greatest hits, if you want to call it that. What are the top 10 things I need to be concerned with? I think that books, learned treatises, there are a number of them that have been written in regards to the things that an attorney needs to know. Buying all of these treatises might be $500. Pratt has a good one. The late Shannon Pratt. Your book is solid. I believe that our soon-to-be published book is very good. So get them all. And, you know, I think certainly the good thing about that kind of study is you'll have a bunch of questions. I think that personally, in addition to their CLE, Tennessee Society puts on a fantastic program that would cover all of the issues, the financial issues, the legal issues, as much as could be, although they try to have legal speakers as well, judges talking about the relevant cases. So that kind of a conference, I think, is invaluable because it rather than shooting things with a shotgun, they're able to focus in on what are the key cases in that regard.
The other concept I wanted to get your idea on is, and this is what I speak about when I speak just to lawyers and specifically people that are looking to prepare for their first divorce with a business valuation engagement, is that once you have two competing business valuation experts, that the odds are that the differences between those experts are going to be issues that number less than 3, and maybe even only 2 or 1. Would you agree with that? In all material respects.
I would say yes, with a caveat. And if you have 2 seasoned experts, if Chris Mercer is on one side and I'm on the other, those 2 experts would know exactly why they're different. And generally speaking, it is 3 or less issues that create the material difference. Yes.
And here's my follow-up point. I want your opinion on this, that as the young lawyer, you can go focus all you want on those 2 or 3 issues. You don't have to know everything about business valuation theory. You don't have to have read any of Chris Mercer's books, QM, DM, or whatever, to really become educated and comfortable arguing those 3 issues, or at least directing your expert, because your expert's going to help you. Would you agree with that?
I don't agree or disagree. I will just say this. If you're, I think that's a personal decision, Miles, because some people have the ability to, it's good that we're talking about books because to me it's analogous. Some people have the ability to read 3 chapters in a book and know what the whole book's about. Other people don't. The other thing is, what if they pick the wrong 3 chapters? So, let's distill this down. Do you want to rely on your expert for understanding this backwards and forwards? Absolutely. In an ideal world, would it be nice for you to understand the issues well enough to be able to call your expert? Because you know what? There are a lot of bad experts out there. And you might tell me there are a lot of bad attorneys. And I think of all valuation knowledge as a 10. And the best anybody can hope for, whether they're an expert or an attorney, is to get to a 9. Okay. I've been doing this for 40 years and I feel like I'm maybe at an 8. And a lot of that is just practical experience that you can't get any other way, just to do it for that long. A lot of the times with lay people, judges and attorneys, maybe all you ever is a 5, Does that make sense?
And
Does
that's
that
kind
mean?
of, it's kind of where I'm going, Kevin, is that yes, you should work to have your basic fundamental understanding of the process and the theory, but a lawyer shouldn't be overly intimidated about the details because they're going to have help and they can go research and they can go read from that library you suggested they read to become competent in order to just ask the questions.
And let me reword that just a little bit. You know, if you say, should a new attorney ever feel like they need to know everything the first time they're in the courtroom? The answer is no. It's an elephant. It's a huge elephant. The elephant of valuation knowledge. I've been doing it for 40 years. I'm still chewing on it. And so there's no way an attorney can be expected in any way, shape, or form to know it as well. So I would just, tell them, take a bite at a time. You take a bite, have your expert take 2 bites. You take another bite, and just communicate. I will tell you that the other thing is this. The thing I like to do, and who knows, maybe I've made less money, probably have in doing this. Knowledge is useless if it isn't shared. And I feel that, acutely. So I have attorneys that will call me up and they ask me technical questions. And the only time I'm going to charge them is if I get engaged on a particular job. Otherwise, I'm happy to raise the bar, educate. That's this stuff we're doing right now. I love this. I had a call earlier today from a firm in out of state, and I alluded to it earlier. They had some questions on an industry that I have some proficiency in, and they said they'd be happy to pay me for my time. Well, if all I'm doing is sharing knowledge, that's why we're here on this earth. Share knowledge. I'm not going to charge somebody for fulfilling my responsibility as a universal citizen. That's why we're here.
Yeah, and I actually wrote in my forensic accounting desk book how to invite a forensic accountant out to lunch and survive it.
Yeah, that's great.
So I try to teach the lawyers exactly that. Don't be afraid to pick up the phone, give a call. It's a Southern thing, but I do recommend you take them out to lunch, at least buy them a meal, and then ask a few questions. And if the expert can answer questions in sentences with 10 words or less, they're a keeper.
Yeah, I'm not that guy.
No, but at least your sentences are interesting. All right, we'll take that.